Welcome to the third webinar of the Space Legal series organized by McGill University Institute of Air and Space Law, IASL, under the leadership of my good friend, Professor Jakhu, and by the International Association for the Advancement of Space Safety, IAASS. My name is Tommaso Sgobba. I am the Executive Director of IAASS. This webinar benefits of an outstanding panel of experts from industry, academy, insurance, and government research center. They are convened to discuss a specific proposal for an operational and regulatory framework to ensure space debris removal. The proposal is the outcome of a joint study performed by McGill, IASL, and IAASS. And it moves from the consideration that according to the assessment of major space agency, stabilizing the space environment requires the active removal of at least 5 major space debris, which means defunct satellites and spent upper stages for the coming 100 years. So this number may sound a bit trivial compared to the hundreds of thousands to millions small and tiny fragments that populate the orbital environment, but instead it is a major effort because spacefaring countries should first of all agree to enforce common rules to make mandatory the orbiting of future spacecraft and upper stages at the end of their mission lifetime, while investing substantial resources for the coordinated removal of all the major debris. To lead the panel discussion, today we are fortunate to have Dr. Lucy Stojak, Executive Director at Mosaic HEC, Montreal's Innovation and Creativity Hub. Dr. Stojak has over 30 years of experience in development and management of international, interdisciplinary, and intercultural education programs. She is the chair of the Canadian Space Agency Board, SAB. She has been a member of the Canadian delegation to the international organization, such as the Conference on Disarmament in Geneva and the EU. I would like now to yield to Dr. Stojak, and she will introduce the speakers and panel members and get the conversation started. Thank you.
Thank you very much, Tommaso, for your introduction, and hello to everyone. So good morning, good evening, good afternoon, depending on where you are. I know we have a full crowd, many participants, including one of our own panelists who is in Australia. So many thanks for joining us. As Tommaso Sgobba just mentioned, the objective of this workshop is to really address the proposal that was put forward and co-authored by the IASL, my alma mater, and the IAASS, and to get a discussion going. And so before I, at the end, maybe mention a few housekeeping points, let me just provide you with the structure of how this webinar will unroll this morning. So we will begin, first of all, with 2 presentations of a first paper which will set the ground on some of the main issues of the proposal that will be made by Kiran Vazhapully, and I will introduce each speaker in more detail before their turn comes up. This will be followed by a second paper presented by Kunstadter, who will give a perspective on, from an insurance policy perspective. Each of these speakers will have 15 minutes. That will set the tone. Following which, it will be a great pleasure for me to introduce our fantastic panel. Each of our panelists will have 5 minutes to make an opening statement, and then we will have an opportunity for questions, first addressed to the panel and amongst the panelists, and then of course the second objective is to get your input and feedback and expand the conversation beyond the panelists. So as also highlighted by Tommaso Sgobba, our panelists are from diverse backgrounds, representing people with technical backgrounds, policy, law, but also importantly coming from different stakeholder communities within the space sector. So people from academia, but also individuals with long experience with space agencies, with government, with the private sector. So we're eager to kick off the conversation. Maybe just a few quick housekeeping points. This webinar, of course, will be recorded and will be edited and provided at a future date. We ask everyone, perhaps the most important point, we ask everyone to please remember to keep your microphone muted to ensure that everyone can benefit from the discussion and hear everyone very clearly. We encourage the members of the audience to send in your questions by using the chat. Kiran, who is our first speaker, has also been invaluable setting up this webinar and will be assisting also technically. So he will be monitoring the questions, providing them to me, and I will be presenting them for discussion. So our panelists, very quickly, are Kiran Vazhapully, who is from the Secretariat of Asian and African Legal Consultative Organization. He's also on leave, doing his master's at the Institute of Air and Space Law. He will be followed by Chris, who's from the Space Agency. And our panelists are Stephen Freeland, who is a professor of international law from Western Sydney University, Isabelle Rongier, who is General Inspector with the Ariane Group, Joe Pelton, who is Dean Emeritus of the International Space University and of its board of directors. And it was a pleasure for me to actually work at ISU when Joe was the dean, and it was a great honor and a great pleasure. We also have Jason, who is head of future business from Astroscale. Josef, who is a satellite systems director at the Space Policy Group with the Aerospace Corporation. Tomaso Zgoba, who's executive director of the IAASS. And of course, Ram Jakhu, who is associate professor, acting director at the Institute of Air and Space Law, and who has been a longtime friend and mentor and colleague. So I'm very pleased to be here. So I will pass the floor now to Kiran, who has 15 minutes to present the broad basic points that have been raised in the proposal drafted by the IASL and IAASS. So Kiran, the floor is yours, please, for 15 minutes.
Thank you, Dr. Shivak. I will take maximum 10 to 11 minutes and possibly wind up sooner than the allotted time. Let me begin my PPT. As we all are aware of the threats that space debris poses to space activities, I wouldn't spend much time describing the problem as such. Suffice it to say that big debris, that's dead satellites, and the spent rockets has been a big issue, and collisional cascading, otherwise known as Kessler syndrome, makes this problem all the more acute. With the ASAT tests that's been happening of late, and with the increasing number of satellites, especially in the lower Earth orbit, this problem has all the making of a classic tragedy of common. Again, as we all know, the legal framework that's existing is not adequate to comprehensively address this problem. The space treaties, for one, that came into force in 1960s and 70s, do not comprehensively address the issue of orbital debris as such. UN Space Debris Mitigation Guidelines, IADC guidelines, and the latest iteration of ISO Space Debris Mitigation, the so-called soft law instruments, have also been not very effective, primarily because of their non-binding nature, and also because they only focus on mitigation as such. Apart from mitigation, in-orbit debris, in-orbit servicing and active debris removal also forms the mainstay of making Earth's orbit sustainable for future use. Today, we are going to speak about active debris removal only, and the study, the proposal focuses on an enforceable legal arrangement, and it strongly advocates that an institutional legal arrangement for active debris removal (ADR) activities is the need of the hour. Admittedly, there are several models that are being suggested by various experts, and the Intelsat model that McGill IASL-IAASS study proposes is just one such model. Today, we are focusing on the model that's based on the original Intelsat as an organization. Why is this model worth emulating? Before I move on to the specifics of the proposal as such, let me tell you briefly the story of the Intelsat. Intelsat, or International Telecommunication Satellite Organization, was the product of the US-led efforts to establish a global system for telecommunications. Its negotiation began in 1962, which resulted in two ad hoc agreements, the interim agreement in short, and the special agreement. These, in fact, gave birth to the Intelsat, the earlier Intelsat. In 1971, these two instruments, the 1964 instruments, were superseded by Intelsat Agreement and the Intelsat Operating Agreement, respectively. And Intelsat, as a formal organization, was set up in 1971. So the Intelsat model essentially follows a two-instrument approach. The first instrument, a multilateral treaty that could only be signed by states, and the second instrument, the operating agreement, that each state party was required to sign or to designate a public or private telecommunication entity to sign this agreement. So essentially, private entities were also part of this arrangement. Thus, the original Intelsat setup established a unique public-private participation model with technical, economic, and even political benefits flowing to all participants of this common cooperative effort. So the first of these two instruments, the Intelsat Agreement, among other things, sets out the scope of activities of the Intelsat, the financial principle upon which these activities would be based, and the structure of the organization. As regards the structure, there are four main organs of Intelsat. First one, the Assembly of Parties. Second, Meeting of Signatories. Third, Board of Governors. And fourth, an executive organ responsible to the Board of Governors. The second agreement of this package, the Operating Agreement, sets out the rights and obligations of each signatory. That includes the obligation to make financial contributions to the organization, the basis and modalities for determining investment shares, and third, the utilization of charges and revenue. The determination of investment and ownership shares were particularly a thorny issue during the negotiation stages. Finally, the principle agreed upon was that each signatory to the agreement would have an investment share proportional to its use of the Intelsat space segment during the 6-month period immediately preceding the date of determination of investment shares. Finally, this arrangement was changed when the original Intelsat became a private company in 2001, and now it's a private entity that's incorporated in the United States. So this is the constitutive story of Intelsat in brief. Now let's move on to the specifics of the McGill IASL-IAASS study. The study essentially advocates establishment of an intergovernmental organization that's based on the earlier Intelsat model to procure the development, deployment, and commercialization of satellites for debris removal. This organization could later transition to a private organization just like Intelsat did. And we can call this proposed organization INREMSAT, that stands for International Debris Removal Satellite. The second element of this proposal is a separate legal instrument to remove on commercial basis existing big debris, that's dead satellite and spent upper stages created by national space activities. The criteria of selection of what kind of debris should be removed will be finally agreed among those signatories. However, the final decision on this matter rests with individual states. The non-participating states to the proposed INREMSAT agreement too will be invited to join this separate legal instrument. So that's the second pillar of the proposals that the study make. The third element is introduction of a space garbage collection tax. States committed to removing their own debris may impose at domestic level, they can impose a space garbage collection tax. The incidence of such tax will be on the final users of the space-based commercial services available within that particular country. And fourthly and finally, introduction of an assured removal clause in national space licensing rule. These states may introduce an assured removal clause in their national licensing rule as a prerequisite to obtain launch or operating license for a satellite by means of a national or foreign launcher. This clause apply to both the satellite and the upper stages of the launcher. Specifically, this clause would require the operator to demonstrate that the systems in question have the capability to perform autonomously at the end of life, a safe controlled re-entry, or removal to a graveyard orbit, just like GSO, or that they have contracted the proposed organization, that's INREMSAT, or a similar commercial provider for such activity. And finally, but importantly, the operator would be required to take an insurance policy in case of a failure or malfunction that prevents performing the initially foreseen autonomous disposal. The insurance company would then procure the covered cost of the relevant disposal service. Chris will expound more on this in his presentation. Finally, to conclude, the study strongly believes that international cooperation between governments as well as public and private sector operators is a sine qua non for successful active debris removal activities. And Intelsat provides a good example of this collaborative global service. Several features of Intelsat are worth emulating in this regard. For instance, adoption of a two-instrument approach, and secondly, the investment share model that the operating agreement proposed for the original Intelsat. So this is the study, the main proposals of the study in brief. Over to you, Dr. Stewart.
Thank you, Kiran, for that explanation of the different elements contained in the proposal. I think also you very clearly demonstrated the fact that the issue of space debris is really based on the desire to ensure that the space environment remains sustainable for all actors to use, and that this sustainability, overarching sustainability goal for space debris has several pillars. So of course, space debris mitigation is important, and active debris removal is also a pillar that will help us hopefully achieve the sustainable goals. You mentioned several issues, including insurance, need for insurance either by operators, needs of changing national legislation to cover insurance. So this is a perfect introduction to Chris Kunstadter's presentation. So again, Chris is Global Head of Space at AXA, leading insurance company. He has been in this business for over 30 years, so he knows about risk management and all the issues related to that. He currently also is chair of the Committee of the International Union of Aerospace Insurers, and is an active member and chairs the policy working group of CONFERS, the Consortium for Execution of Rendezvous and Servicing. So Chris, please, the floor is yours for your introductory paper on the insurance perspective on this issue. So 15 minutes to you as well. Thank you.
Thank you very much, Lucy. I really appreciate the introduction. And I'm assuming you can all hear me, and I'm sharing my screen, so we'll get started here. So as Lucy said, I'm Chris Kunstadter. I'm the Global Head of Space for AXA-XL. We're a US-based global commercial insurance company. I want to thank the IAASS and the IASL for sponsoring this panel and inviting me to participate. So my company, AXA-XL, is a major player in global space insurance, and in addition to our leading role in major space insurance programs, we're the market leader in insurance for small sats and small launch vehicles. In addition, we've supported all of the commercial on-orbit servicing and repair missions that have been undertaken in the past 35 years, as well as a number of upcoming on-orbit servicing missions. So my goal for today is to describe the current state of the space insurance market and to emphasize the urgency of developing an international framework for the mitigation of collision risk in orbit. We will have a bad day in space, and we do need to be prepared. So space insurance enables innovation and investment, and without space insurance it would be very difficult or impossible to sustain the commercial space economy that we've worked very hard to build. Secondly, we can use our leverage to incentivize good behavior. We have to emphasize to our clients and the broader space industry to not just meet the basic requirements of, say, licensing, but to go further and be role models for good behavior. In the past several years, we've experienced an increase in launch and satellite failures, not just new models, but even those with significant heritage. At the same time, the increase in LEO constellations and rideshare launches has resulted in lower premiums into the space insurance market. And the broader insurance market as a whole has been affected by catastrophic losses such as the pandemics, extreme weather, global political instability, and low interest rates that affect investment income. So the insurance market is well aware of collision risk. In fact, one insurance company even withdrew from insuring LEO satellites due to the perceived increase in collision risk. And it is time to take action. At AXA-XL, we work very closely with companies developing technologies to enhance space safety. One of the things that was mentioned was a paper that's coming out for the IAC, identifying the 50 statistically most concerning derelict objects, i.e. rocket bodies in most cases, in low Earth orbit, that I co-authored with Darren McKnight as well as a number of other people. But we're at a critical point and we need to act now. At AXA-XL, we embrace risk. We don't shy away from it. We look for opportunities to insure risk. We innovate in this changing market by being a leader in small sat insurance and low Earth orbit constellations. But most of all, we encourage responsible behavior in space. We want everyone to maintain space usable for everyone. So if we look at some of the metrics that we use in our analysis, you can see that to date in 2020, there have been more launches this year. Despite COVID, despite everything else, there have been more launches this year than in any year in the last 10 or 11 years. So it's quite a dramatic rise in the number of launches. At the same time, here with more than 3 months to go till the end of the year, there have been more satellites launched this year by far than any other year in history. 870 or so satellites launched. So it is getting crowded up there. A lot of GEO satellites are operating beyond their design life. We have over 100 satellites that we've identified that are operating beyond their design life, and in the last several years we've seen a number of anomalies where satellites have either had debris shedding events or simply died in the geostationary arc and have created quite a mess for satellite operators. So again, another situation where we need to clean things up. So what is space insurance? We look at risk management as a three-step process: identifying the risk, assessing it, and treating it. And the treatment options include either avoiding the risk, reducing it, retaining it, or transferring it to the insurance company. But a couple of the very important principles of insurance, especially when we're talking about things like debris removal, are a pooling of risk and fortuity. We are not insuring against things that we expect to happen. We're insuring against things we do not expect to happen, and that's why we have to pool risk. We cover virtually the entire technical risk from launch onwards. So whether it's a mechanical failure of a rocket or a satellite, or a micrometeoroid, or a collision, that's covered. There are a few things that aren't covered, like war and terrorism, but virtually everything else is covered. It's a very volatile insurance. The technologies are always changing. The business is always changing. The premiums are insufficient these days to cover the losses we've had, and it's a very difficult business to maintain. So we've had to do a lot of work to make sure that our management understands the products we're selling. So the middle blue line here is launch. We cover the pre-launch phase, we cover launch, we cover on-orbit activity, and even re-entry for example, the Dragon capsules to the ISS. So we cover the full range of risks in space, and especially our work on on-orbit servicing has really helped us to focus on some of these. If we look at the number of satellites that are in orbit, there are about 3,200 active satellites today, of which over 80% are in low Earth orbit and other orbits. And very few of those are insured. Very, very few of those are insured, just some of the smaller constellations and things like that. In GEO, a lot more satellites are insured because they're expensive, they take a lot of resources, and they generate a lot of revenue. But if we look at the space insurance market, we see that from 2002 to 2012, the premiums that were in our market were between $750 million and $1 billion. But since 2012, the premium dropped by 50% to 2019, to the point where it was not a sufficient premium to cover the losses. Now, the important point to make here is that the claims last year, in 2019, were in family for this class. About 800 million of claims last year, but we've seen that before. It's the premium that has really dropped significantly. The business is profitable if it's priced correctly, and the prices have indeed increased in the past year by 2x or 3x, 2 times or 3 times. Even though that's the case, you can see that even in 2020, the premium probably won't make it even to the level where it was last year, despite this massive increase in pricing. And in fact, if you remember that graph of the launches since 2010, 2020 was the highest year ever, and this year, 2020, looks to be possibly the lowest year ever in terms of insurance premiums. So it's a tough time for us to justify to our management. And so what's happened is, of course, that pricing isn't driven by experience. Pricing is not driven by the fact that there have been losses, but simply by the fact that some insurance companies have pulled out of the insurance market. As a result, capacity being down, supply and demand, pricing has gone up. If we look at anomalies, now moving towards the in-REM-SAT idea, if we look at when anomalies happen, we see that 34% of satellite losses occur in the first 2 months after launch. That's really the very risky period for satellites. And as satellites become smaller and have less testing, we're going to see more and more losses occurring early on in life. Here's where in-REM-SAT really comes into play. So if we take GEO satellites launched since 2000, of the 625 GEO satellites launched since 2000, 75 of them have suffered major anomalies, losses of capability that could have benefited from on-orbit servicing. So of those 75, 60 of them would have benefited from inspection and repair, and we've been very supportive of some satellite inspection organizations. 37 of them would have benefited from life extension by attitude control, orbit control, or power augmentation, and 26 of them would have benefited from reorbiting or deorbiting. Reorbiting meaning taking to the graveyard orbit, deorbiting meaning bring down to burn up in the atmosphere. And if you annualize those, there certainly are a lot of opportunities every year for on-orbit servicing. And these are just the satellites that had major anomalies. A lot of the satellites in this group of 75 could have benefited from more than one type of servicing, but a lot more satellites would have benefited from life extension and end-of-life disposal. So this is where in-REM-SAT comes in. Is this an opportunity for in-REM-SAT to to do a lot of this activity removing satellites, in this case from GEO, but obviously also from low Earth orbit. So this is my get off the stage chart. I just want to recap that space insurance is vital for investment and innovation. And we're concerned about the way the business has gone in the last several years. In fact, insurers in general, as I said, are concerned about the massive catastrophe losses we've seen. So to sustain a safe environment, we really need to act now. We can't wait. And the same rules that apply in your house apply in space. Don't make a mess, tell people where you are, and clean up after yourself. What we need is role models. We need role models and anchor tenants. We need people to say, yes, we will try out in REMSAT. We will make use of it. A lot of issues have, we see a lot of issues around things like cost and allocation of responsibility and liability, and getting governments to agree on things like an in-REMSAT structure. But it's definitely something that we would like to pursue. And bottom line is, being responsible is the baseline. It's not the aspiration. Being responsible should be the minimum standard. We encourage people to use things like the World Economic Forum Space Sustainability Rating that encourages people to go above and beyond in aspiring to be the best operator in space. So being responsible is good, but you can do a lot more. Thank you.
Thank you very much, Chris, for that great summary. A couple of key points that came out: a good behavior, responsible behavior, maintaining a sustainable environment for everyone by behaving responsibly. How do you follow up on that if you don't act responsibly? Perhaps is a question we could address later. The importance of having champions, your role model idea, I believe, is a key point. And also, hopefully, during the questions, we can dwell more into how you were able to determine the 75 satellites that could have benefited from servicing. Perhaps these metrics are something that might be of value later on. So thanks again for these opening presentations. Again, during the general question period, we will be able to address questions specifically to Chris and or to Kiran. But now we will turn the floor to our interdisciplinary panelists. So again, just as a quick reminder, each of you will have 5 minutes to present your views on what you just heard. We will then open it up for questions first amongst yourselves and then to the general audience. So the first person that I would like to invite as our panelist today is Professor Stephen Freeland, who's a professor of international law at Western Sydney University. He also has had a lot of experience in advising different space agencies and governments in Australia, in New Zealand, and in some other countries. And he also works very closely with COPUOS, and currently was appointed by COPUOS to co-chair a multilateral discussion on the exploration, exploitation, and utilization of space resources linked to the legal subcommittee. So Stephen, the floor is yours. Thank you.
Thank you so much, Lucy, for that kind introduction. Hello, everybody. It is about midnight here in Sydney. So I wish you all well, and I hope you're enjoying a better time of the day than I am. Thank you also to the IASL and IAASS for inviting me to this webinar. I've had the honour of participating in all 3 of your webinars, and they just get better and better. And thank you to Kiran, and thank you to Chris also for fantastic presentations. And I know we're going to have a great discussion. So I've been given 5 minutes, which doesn't sound very much, to comment particularly on the proposal. And I have a lot to say, so I will only really raise points, and hopefully in the discussion we can flesh them out. And of course, people are free to contact me separately afterwards. So I'm going to respond to the proposal. The obvious starting point is, of course, space debris and the escalation of and cascading effects of space debris are probably the greatest challenge we have in relation to the ongoing sustainability of space activities. So every proposal, every thought, every initiative that is directed, and every technology, of course, that is directed towards addressing that, both from a debris mitigation perspective, but also from a remediation perspective, should and must be considered seriously to take into account. So what I would like to do is just make some comments on this specific proposal. My comments sound like criticisms, they're not. What I would want to do, though, is just raise the points that I think we need to consider before rushing into any proposal, notwithstanding the fact that we need to move as quickly as we can. So what are the issues that will be raised? There are, in a sense, logistical issues, there are legal issues, there are funding issues, and there are diplomatic issues. From a logistical viewpoint, setting up a structure like Intelsat is complex. That's not an insurmountable thing. We've done it once before. But we need to look at reasons why, in the end, Intelsat, starting off being very, very successful in what it did as an intergovernmental organization, but actually was, in a sense, forced to privatize, as Kiran referred to later on, because the technology moved forward and Intelsat could not make decisions in a timely way. Intelsat could not access sufficient funding to keep up with the new technology. Competition arose, and the competition was both upset at the fact that Intelsat had this special status, but also the competition was moving more quickly and had access to the capital markets. And so Intelsat itself was not being able to be as nimble as is necessary in a fast-moving technological domain. So there were some logistical issues, okay? And so an INREMSAT proposal would face similar issues. We'd have to address them. From a legal perspective, I would say we must not put the cart before the horse. We need to understand the legal issues, and we need to work out ways to find an understanding as to how those legal issues should be addressed. There are many legal issues that arise when it comes to particularly active debris removal. From the basic issue about what is space debris, now many people say space debris is related to its non-functionality, and that's the definition that we've seen in the IADC guidelines. But even that is questionable, because even some non-functional objects have value. They might be in reserve, they might have particular proprietary information or national security information or whatever. We have got issues of jurisdiction and control over these issues, pieces of debris, and sovereignty issues. We've got liability issues if things go wrong. We've got to work out if we can create the technology to remove debris. There's always the perspective that that same technology can be used for nefarious purposes. We need to work out responsibility, who is responsible for the existing debris, and we need to work out other things like protecting confidential information. I mean, if you're going to collect a piece of debris, you need to know a lot about that debris, and there's confidential information that might be patented or whatever. From a funding viewpoint, I understand the proposal has the idea of a garbage tax, I think it's referred to. Ultimately, that tax will be passed on to the end users, the consumers, and raising the costs associated with activities of INREMSAT, which in fact might push consumers to competition anyway. That might be cheaper, and then you have that same spiral of competition being more nimble and being able to react, and INREMSAT has to adapt to that. In terms of perhaps the idea of a global fund, and I know my dear colleague and friend Joe Pelton will talk about that later, a wonderful idea, but we have tried to establish global funds in the past for major issues of global concern. We had the attempt at what was called a Tobin tax to relieve third world debt. It didn't work because countries and private entities were not prepared to contribute. We've had CDM mechanisms under the Kyoto protocols, which frankly have not been successful, even though they've involved carrots and sticks and a financial incentive to do certain things. So we need to deal with that. And then the last issue, and then I'll stop, Lucy, although there's much more I could say, of course, is the notion of getting everybody in the same room to agree to establish this INREMSAT. The proposal said, well, we could have a small number and then build it as we did with Intelsat. But I have to say, in this geopolitical climate, that probably is not an appropriate thing to do if that small number does not include all of the major spacefaring countries, and particularly those who might be seen as having been responsible for creating the vast majority of the debris. So unless we can get them all in the same room to agree, the idea of setting up rules for certain players, but not for other major players, might cause some concerns, might lead to not standardization, but it might lead to a lack of standardization, which threatens then best practice. It threatens the idea of sustainability. It threatens the idea of cooperation. And of course, the whole notion of INREMSAT relies upon common interests and cooperation. We all understand there's a common interest to do that, and we must continue in our language to promote that common interest and the idea that sustainability and, as Chris said, responsible behaviour has to be the benchmark at the very minimum, and we must go beyond that. But this is a difficult time, and so getting people to reach that consensus to form this intergovernmental group will take time, and it will be difficult, and in the geopolitical climate we are, it may not be possible. It may, even notwithstanding the fact that we all think it's a great idea. So I'll stop there. I don't want to sound as if I'm being negative about the proposal. I'm not, but I am saying we must be realistic. We must look at all proposals, and there are others dealing with debris, and the UN itself is dealing with this, albeit in sometimes relatively slow ways, but we have got some excellent guidelines. There are many issues. This proposal has lots of merits, but I think we really are at the beginnings of trying to discuss the best way forward. I hope some of the issues I've raised will be elucidated by my dear colleagues who are going to speak after me, and I'll look forward to the discussions and any questions that come. Thank you, Lucy, for giving me the floor. Thank you.
Thank you, Stephen, for highlighting some challenges with the proposal. I think this proposal is a call to action, and I think this webinar is perhaps the first attempt to brainstorm and discuss it and improve it. The points raised about the geopolitical situation as compared to when Intelsat was created, I'm sure will come up and be addressed by other speakers, as no doubt issues of liability, jurisdiction and control. So thank you for setting the stage for some of the upcoming speakers. I'm now pleased to pass the floor to Isabelle Rongier, who's a general inspector with the Ariane Group. She has a very long experience with space agencies, with CNES, the French Space Agency, particularly in the field of launchers in the systems department, very much involved with quality control, safety, space debris, and risk management. She was also extremely active with the IAASS, and since October 2017 is now the Emeritus President of the IAASS. So please, Isabelle, the floor is yours.
Thank you. You hear me?
Well.
Okay. Okay, so thank you. I wanted to highlight a specific issue with respect to rocket bodies, these famous spent upper stages, in my 5-minute speech in order to introduce the discussion for this specific debris. So just before the IAC 2020 Cyberspace Edition that will occur in a few days, there is something which is very interesting to know. Chris has already spoken a little bit about it. It's an article about the 50 statistically most concerning derelict objects in the LEO orbit. What is the statistically most concerning? It's a question of proximity to operational satellites, of persistence of debris, and of ease of retrieval collectively. So among these 50 debris, you will see that 39 of them, so that means 78%, are old rocket bodies. That's why it's very important to speak about that. This study was based upon existing two-line elements catalog, and these 39 old stages are in very great majority old Russian and Soviet stages before the year 2000, with a mass which is between 1.5 tons for the Cosmos and around 9 tons for the Zenit. But in addition to this case in LEO, where it is a little bit catastrophic, there is another case where the Russian ISN network, which was also confirmed by a French space agency analysis, confirmed that some Atlas V Centaur upper stage fragmentations occurred during 2018, 2019, and the problem was the crossing of the GEO protected zone. So of course there is no active debris removal in GEO, but we have also to be aware that it's very important to know all old rocket bodies that are crossing LEO or GEO, because everything is not present in the TLE catalog, which is accessible to all of us. And so we have to pay specific effort for these big and old objects to have a complete view of the risk that we will have to sustain when they will cross the roads of satellites, because they may have a very big explosion, fragmentation, and generate a very large number of debris. So how to solve this problem? First, as it was also said by Chris and Stefan, we have really to promote education. Lucy, you spoke about to act responsively. Everything is based on that dialogue, explanation. What are the figures? What are the best practices? What are the worst practices also? How we will go to a non-sustainable space if we are going like that? What are the associated risks? And of course, we have to be realistic, Stefan, as you said, but if everybody shares what has to be done, it will be easier to find a solution with respect to all the legal and political aspects, which are very, very important for active debris removal. First, we should recover the current situation, because these very old stages are very numerous in the LEO orbit. It's perhaps an easier situation compared with the whole landscape of active debris removal, because for these old spent upper stages, there is, at my point of view, no political risk. There is no danger to catch some interesting technical know-how. There is no problem of frequency like for satellites. For sure, there are legal issues that we have to handle with care, but it's probably more easy to begin with such kind of objects. And then they are quite big. It's probably, from technical point of view, easier to handle compared with a satellite. And there is still a lot of possibilities to grab, these old tanks or by the nozzle or things like that. And the best solution could be either to deorbit them in a controlled way to Earth, or to put them in graveyard orbit, which doesn't present a danger anymore. So all that can be studied and can be handled with the solution that we are discussing today. For the future, for sure, if we do not enforce by national rules the best practices that are well known, we spoke several times about IADC ones, or ISO, which is coming also, but we have for 10 years now a law in France, an act which is called the French Space Operation Act, and which asks to have a mastered re-entry for our rocket upper bodies launched from the French Guiana, so applying to Ariane, Forshaw, to Soyuz, and to Vega. These rules in the French Space Operation Act are totally linked to the best practices that we know. And I have recalled them here, not to describe everything because it would take too much time, but really to say that for 10 years now, the French Space Operation Act purpose is really to bring safety for all the parties, all the stakeholders, to guarantee the public health for people on ground, to ensure the environment on ground or in space, and to have specific requirements for space debris mitigation. So more specifically, 2 articles deals with space debris limitation for these rocket bodies, the upper span stages, where you will find, again, there is nothing new, but it's something which is enforced before each flight from French Guiana, and which will ensure in the future that the current situation we face now with these 39 bodies among the 50 most issuing debris will be solved. So this example, of course, can be improved because there are still some waivers which are possible. You cannot be perhaps 100% strict when you begin on that. But what we see today is that from European point of view, the situation is really better than 10 years before. So I hope that this example will help other people. And I really hope that the rocket bodies that are really damaging the space sustainability right now will be the first cases of the 5 pieces per year mentioned by Tommaso in the beginning. So I will really be glad to answer some questions and to discuss the subject with you afterwards. Thank you.
Thank you very much, Isabelle. Interesting to highlight how national legislation can help support sustainable moves to maintain the environment cleaner and to deal with space debris, and also interesting to try and address perhaps objects that I think the words that you used had less political implications, such as the old rocket bodies, to begin with the cleaning up of space and the ADR. So thanks for those important points. Our next speaker is Joe Pelton, who was, as I mentioned earlier, Dean Emeritus and former chairman of the Board of Trustees of the ISU. He's also the founder and former executive director of the Arthur C. Clarke Foundation. He has been actively involved with the IAASS and also with the Institute of Air and Space Law in various studies dealing not only with space debris but also telecommunications. He's a prolific writer. I think that Joe has more batteries than all of us. I don't know when he sleeps to be able to write such great pieces of great articles and books, notably Space Debris and Other Threats from Outer Space and New Solutions for the Orbital Debris Problem. He also has a wealth of experience with Intelsat, having worked there for many years in his career. So Joe, the floor is now yours to walk us through Intelsat and the proposal and why this was included as a good way to advance on the ADR front.
Okay, Kiran, can you put the slides up? First of all, I just want to say good morning, good afternoon, and good evening to everybody. It's a pleasure to be here. So Intelsat has some very good points that Kiran has brought out. One of them is that there was a real market need and a, if you will, a market thrust to create this. Intelsat came out of an initiative from the United States. There was the passage of the Communications Satellite Act of 1962, And this was a compromise. There was one bill in Congress to have it all governmental, another to have it all private, and the Kennedy administration came up with a compromise that was the ComSat Corporation. Immediately, the U.S. Started talking to countries of the world and saying, we'll set up a series of bilateral agreements to make this happen, to get it started. When the U.S. got to Europe, the Committee on European Post and Telecommunications said, no, we have to have a intergovernmental agreement, and that's how the process started to actually create such an organization. Some of the features that were negotiated that are very important is the idea that contractors would be the key to make this happen, so that there would be contractors to make the launch arrangements and contractors to build the satellites, and Intelsat would in effect sort of manage this process. And this is where I think there is some relationship to the proposal here. But there was also a real market incentive. Investors were to receive a 14% return on investment. But as noted, it took a long time. It basically took 2.5 years to get from the start in '62 to the interim arrangement, and then it took till '71, from '65 to '71, to get the actual intergovernmental organization agreed. And then I was actually involved with the transition from ComSat as the manager of the system to an international management that took another 2 years, and that was 2 of the most demanding years of my life to get this negotiation agreed and the executive organ of Intelsat created. So the key is we have an urgent need here, but these things take a very long time. Within the UN, it took 18 years from the start of the process to the end of the process to get the debris mitigation procedures agreed within COPIUS and then agreed by the General Assembly. But the main point I'm making here is that with active debris removal, there's no established market, and there's a classic problem of economics of who pays. In the seas, there's the issue of the lighthouse. Who pays for the safety of the seas, and how do you get a market established to make it happen? So the next slide notes, if you will, some of the problems with the proposal that Stephen has really sort of already mentioned. That the idea is, rather than starting with an international organization, perhaps the other way around. As Isabel was saying, national laws can require establishments, and they could establish a requirement to pay for clean orbit debris fund administered. And I would just note that it would be key for at least, I think, 4 or 5 governments to sort of agree to a model law that basically said we're going to have requirements that there be debris removal, and that the various countries would specify that for all launches, people would pay into a fund, which has been called a garbage tax. In my view, this didn't have to be done particularly that way. It could be paying into a fund that would be very much like a insurance arrangement. And as Chris has noted already, the fact is, if debris could be removed, it could actually help lower the cost of launch insurance because we now have higher and higher premiums because of the risk of the orbital debris. So I think some sort of process to get the launch insurance industry involved in the process would be a very good step. And in fact, I actually have a separate document on that topic. So anyway, governments could pass a law that says that everybody who has a launch could be required to pay into a fund. It could be structured in such a way that if it's a successful launch and a clean launch, there could be some rebate and so on. But the idea is, couldn't we start with a national law and build up to an international organization? The other key point that I really like to make is that there are a number of very key issues that are also involved in terms of space safety. Anyway, the thing is that we need, I think, in space to have the issues of space situational awareness, the idea of operational arrangements with regard to rendezvous and proximity operation, military uses of space. And so the question is, should this organization be limited to just the issue of orbital debris, or could we build up toward a entity that could take care of all of these issues of space safety in terms of the space situational awareness, in terms of mitigation of risk, procedures, dealing with the, if you will, space weapons in space, and so on. So the Intelsat arrangements, I think, do provide some very interesting ideas about how we could get a private activity going that could provide these types of activities. But we also have this issue of who pays, and that it really should be the people who have made the problem who should be paying for the problem. And in Intelsat, the intergovernmental aspect only required a meeting of assembly of parties, so there really wasn't that great of expense at the public level, and that all of the other activities of Intelsat in terms of launching the satellites, building the satellites, and so on, that was all paid by the members who were using and deriving the benefits. So it's a market issue, I think, at ultimately question here about how do we create the mechanisms. And again, I think if we had national laws that set up these kinds of requirements and allowed for private entities to benefit from the amount of money paid into the fund, and perhaps even dealing with the launch insurance, who could pay out the amount of money as if there's successful deorbit capabilities achieved by organizations like Astroscale that we'll be hearing about later.
Joe, if that could be your wrap up, because our next speaker is in fact Jason, so it's a wonderful way to introduce Jason Forshaw, who's the head of future business for the European market at Astroscale. So talking about markets, I think he's in a good position to address that particular point. Important to note, his past experience actually includes a number of active debris removal missions, including ESA's service-oriented ADR remove debris, and I'm sure he'll tell us about a couple of demonstrations that are scheduled by Astroscale. So Jason, the floor is yours, please.
Thank you very much. Good afternoon, everybody. May I firstly thank the organizers a lot for invitation to this event. I have to firstly confess that, unlike many of the panelists here today, I'm not a legal expert, but today I'm best placed to present an industrial perspective, especially from a business and technical side, and of course direct from an emerging active debris removal provider. So Astroscale's mission is to develop innovative technologies, advance the business case, and inform international policies that lead to a reduction in orbital debris and support long-term sustainable utilization of space. So as alluded to earlier, it's well known that in order to stabilize a space environment, space assets must achieve 100% passivation, at least a 90% PMD rate, plus, and here's the crux of the situation, 5 or more large objects must be removed per year. Hence, I guess the whole focus of this proposal. So we are one of the few companies in the world proposing to aid in the removal of orbital debris through both our end-of-life services targeting LEO constellations and thus new satellites which will be launched into space, and our ADR services targeting existing larger debris already in space. Furthermore, we're also exploring life extension services for GEO, which support overall space sustainability by enabling the reuse of space assets. So we are working on a variety of pioneering missions in the debris removal domains. And this comes back to, I guess, what previous people have asked about the market, where are we going? Are things actually happening in this domain? So let me first mention the ELSA-D mission, which we believe to be the world's first commercial demonstration of ADR, which is launching later this year. We spent a lot of time doing commercial developments under the ESA Sunrise program with OneWeb to mature technology for future end-of-life missions. And I might mention the ADRAS-J mission, which is JAXA's first ADR mission to inspect and rendezvous with a large upper stage in light of future removal. So in this forum, of course, this ADRAS-J mission is of special note because it's one of the first times a government or state has taken active steps to develop actual missions to remove debris, and with an end vision of further institutional removals of more space debris after. So of course, ESA has also started the mission to remove existing European assets, and it's possible that after the first Vespa removal, the follow-on could be commercial or institutional in nature. So the concept of a state licensing a company to remove its own state debris is a model that's been trialed at present through these initial pioneering ADR missions. So of course, I've been involved in the licensing of both Surrey Space Centre's Remove Debris mission and Astroscale's ELSA-D mission with the UK Space Agency. And I would say that both of these are kind of important inaugural test cases in developing regulatory frameworks at the state level for international ADR. Of course, moving forward to future missions, if a state or company wants to remove another state's debris, then that's where the legal situation becomes more complicated, especially if there are several launching states involved. And thus, of course, we recognize the need for international law and better cooperation for active debris removal. So with regard to the assured debris removal proposal we're discussing today, I think a lot of very good things have been said. Unfortunately, I don't have time to talk about many of the things, but we do have a few comments. I mean, firstly, the mechanism proposed is quite legally complicated. As Joe and Stephen have already mentioned, it would no doubt take considerable time to implement. I think it's known international law can take many years to develop. You take UN COPUS, that took over 8 years to develop. So we believe that by the time such a mechanism is implemented, some companies will already be offering ADR services. And at that point, of course, the model being proposed will have to be aligned with the actors already servicing in this market. So secondly, the mechanism proposes that the INREM-SAT organization would remove larger space debris institutionally, but could also be contracted for commercial ADR through the triggering of a clause as part of licensing. So it's important to differentiate between whether INREM-SAT would offer or procure commercial or institutional services. So I make this point because both are very different in nature, in scope. You know, in the commercial case, LEO satellites are getting smaller, you know, less than a few hundred kilograms, and the cost per satellite removal has to be very low in order to make the entire business case work. The docking plate, for example, is a device that Astroscale uses to help reduce the cost of commercial services to ensure that we have standardized interfaces. And I think standardization was something that was mentioned before, and I think is quite important in this area. Of course, in the institutional case, missions could be considerably more expensive and satellites could be a much larger size. So I just want to differentiate between those two. So I think I'm running out of time. I just have to say, in conclusion, Astroscale is actively working towards future ADR missions to support space sustainability. And we really do believe that enabling space sustainability needs urgent, concerted, and tangible action at an international level. And this is led by governments and supported by the space industry. So we are very keen to follow how this assured debris removal mechanism evolves, and how governments and the space industry actors view this initiative. So thank you very much. I look forward to upcoming discussions.
Thanks very much, Jason. I think the last point that you mentioned, the need to build between governments and industry from the even conceptual level is a key issue. That's perhaps one of the biggest transformations in terms of governance for future activities in space. Is how do you actually get the voice of industry involved earlier, as opposed to when the early treaties were developed, because of how technology was and the fact that space was primarily government run. So excellent points. Thanks very much for that. Our next speaker is going to be Josef Koller, who again is Systems Director for the Center for Space Policy and Strategy at the Aerospace Corporation. He also had experience working at the Office of the Secretary of Defense for Space Policy in the United States, very much actively involved in outreach activities and a space TV show, I think, that he hosts. And he's currently also serving on the NASA Advisory Council, the Regulatory and Policy Committee, and he's editor of the Journal for Geoscientific Model Development. So it would be interesting to hear your perspective from a policy angle. Josef?
Hi, thank you very much. Yeah, this is Josef Koller with the Center for Space Policy and Strategy at the Aerospace Corporation. It is really a pleasure to be here today. I'm frankly honored to be here with so many distinguished legal experts. Even though I'm not I don't have any legal background, so I'm really honored to be here. Also with some jealousy though, because I do know, I'm a scientist by training. So I'm very much interested in the physics of space as well, and not just the legal aspects here. And I do note that, with some jealousy to my legal colleagues here, because the laws of physics, if you look at it from a physics perspective, can't be changed. I wish it would be nice to be able to change the gravitational constant and make the debris just float away. Wouldn't that be fantastic? But so as a physicist, I can only study the laws of physics. You, as legal experts, actually have the opportunity to change policy, law, international treaty, and so forth. And so that's why I look at you with some jealousy. Although I do recognize changing law, congressional law, and international treaty, as so many of you have pointed out before, might come with some great difficulty as well. But apparently it is feasible. So I've been thinking about active debris removal for quite a couple of years now, specifically during my time at the Pentagon, where I was handling commercial remote sensing licenses. There were some cases on on-orbit servicing, and I think there's some good correlation between on-orbit servicing, the challenges from a legal perspective, from a policy perspective that are correlated to that. And I've noticed through the years that in this paper as well, people like to talk about the significant complex legal and policy challenges. I appreciate those. I'm also a very pragmatical person. And I know many of the legal challenges that are being pointed out are looking at worst case scenarios. And I want to go into more detail on that what I mean. The proposal of creating an international organization, I don't want to repeat myself too much. So really what Stephen mentioned earlier really resonated with me, and I don't want to repeat too many things here. And the proposal of creating an international organization is definitely an interesting one. I call it a Gedanken experiment, a thought experiment at this point. And it's also, and I think that comes with great difficulties, as my colleagues have pointed out previously. I think also using my, based on my experience of being part of the delegation, US delegation to UN COPIAS, I really note that the great difficulties it would come with to establish an international organization. Like somebody said earlier before, to get everybody into the room and agree to something, I think comes with great difficulty. But it's not about changing the laws of physics. Actually, you can convince other people to join you and perhaps start with like-minded countries, to establish something. So I think there are possibilities there. But I think it's also, you have to look at how many states, major spacefaring nations do have to be involved. And I printed out earlier today a score chart. It's probably not visible for everybody, but you can look at spacetrack.org, the public catalog, who actually has most of the rocket bodies today. And most of them are indeed from Russia, then United States, China, France, Japan, and India are among them as well. So these are the top 5 or 6 countries that have most of the rocket bodies, debris rocket bodies in orbit. And so I think that is not a large list of countries. Of course, the list of countries, I would describe them as not quite like-minded on many different levels. So there are some difficulties and some differences there. But I do note that, for example, the United States has, according to this list here, 714 rocket bodies in orbit currently. That is a tremendous list, frankly, right? And Tommaso mentioned earlier that, studies have shown that you should perhaps think about removing 5 major bodies per year. That will get you a long way. If there are 700 rocket bodies available. Regarding the proposal, so I think perhaps a bottom-up approach would be worthwhile to look at as well. Perhaps a debris removal effort within a state. I think that would take care of many different legal challenges that were pointed out. But so I think that there are other approaches, and we can talk about those some other time. But the other 2 points I want to make, without having the legal background, but noting the 2 major legal challenges that were pointed out. One is on the issue on jurisdiction control and sovereignty. Right, so that would actually not, because states are ultimately still responsible per Outer Space Treaty on supervision and authorization, right? So a debris removal within a state, and my statement is there's plenty of opportunity to remove plenty of debris. Some of those issues might actually not arise, but without having, without making major statements on based on a legal argument. Perhaps we could look at precedents. So for example, I would like to point out Space Logistics has recently docked with an Intelsat 901 satellite in an on-orbit servicing mission. And I think there's a great correlation that somebody could look at. And perhaps somebody could make a legal argument that that docking maneuver did not constitute a change in jurisdiction, control, or sovereignty. So perhaps there is an argument that could be made in correlation to active debris removal. Is it, even if there are 2 separate states involved, is there really, can an argument be made, a legal argument be made, that it does not constitute a change in jurisdiction or control, but merely the debris owner is using the company or the service provider for the active debris removal as a means to extend the control of the space debris. Could there be a legal argument made? Perhaps. The last point, and I'll be very quick here, is ITAR export control issues. Of course, they only arise if two separate countries are involved, but it also depends on the technology that is involved. You know, I want to make the joke, a harpoon in space, removing a debris, you might need to understand what the internal technologies are that would trigger then an export control or ITAR issue. External pictures and photographs normally do not convey sufficient technical information to really trigger export and ITAR control. A harpoon in space wouldn't either. And hereby I yield back to you. Thank you very much.
Thank you very much, Joseph. So now it's a pleasure for me. We kept the last two panelists, the two co-authors of the proposal. So it's a pleasure to first pass the floor to Tommaso.
I cannot hear. Okay.
Tommaso, yes. Okay, sorry.
Okay. Thank you. Thank you. I live in the Netherlands, and when I drive on the highways, I see big signs saying drive responsibly. There is some that says Bob does not let friends to drive drunk. But if you try to drive drunk, then you will get a fine that you will remember for your life, or you will end up in jail for a few days. Instead, what I hear are ideas about rewarding the behavior, the good behavior. But there are many people in the Netherlands which drive responsibly, and still there are those that are irresponsible. So what I will talk about now is about a case truly of irresponsibility that was linked to an agency, not even a commercial entity, an agency, and this is EMSAT. So in April 2012, the European Space Agency EMSAT satellite, one of the biggest, largest satellites in the world, with a mass of 8,200 kilograms, which has an overall dimension of 25 meters with the solar panel extended, was left stranded in a polar orbit at 780 kilometers. And this is one of the orbits that is the busiest and valuable LEO orbit. Now it will take at least 100 years for EMSAT to re-enter, uncontrolled the atmosphere. Now, EMSAT was launched with a mission of 5 years, then was extended for another 5 years, then was extended for another 3 years, and eventually it failed at the beginning of the last extension. So when a discussion started about how this happened, then the agency, the European Space Agency, said at the time of the development of EMSAT, there were no rules, no mitigation rules. That's true. But in the period of development of EMSAT, those rules were being written with the participation of ESA, ESA Space Debris Office, ESA Program EMSAT, different entities. Eventually, when the disaster was realized, then there was the question of what to do now. And ESA launched an initiative called Clean Space, with the idea of having a mission to go there, 780 kilometers, and basically the orbit, with the control the orbitation, EMSAT. When the proposal was presented to the Council of Research Ministers, that is the highest governing body of the agency in 2016, they basically said, no, it costs too much, okay? And they agreed to finance not the orbiting of 8 tons, but a small demonstration program of 100 kilograms with an element of an upper stage of a Vega rocket that had been left in orbit. So what are the lessons learned from this? First, the lesson learned is that with guidelines, code of conduct, you don't go anywhere. And so in matter of safety, you have to discourage the use of guidelines, but this must be replaced by harmonized national regulation. If you have competition and everybody goes in its way, US, Europe start having strict rules about the orbitation of upper stages. This reduces the performance of the rocket. The Chinese decide not to do this. They will compete, they will get the market. So first, discourage the use of guidelines, but instead encourage harmonized national regulation. Secondly, there must be an obligation to assess and publicly report the impact of new measures when they are introduced. In the safety field, measures are retroactive. If your car is not up to the task, and now there is a new regulation, you are requested to do something, to continue driving your car safely. So safety regulations are retroactively in many respects. Another point that I would like to make using EMISAT as an example is that cost reduction in the orbitation of system is a paramount to make ADR viable. And this is the main reason of cooperation. So the cooperation between countries is to standardize system and reduce the cost of ADR. And fourth, the selection of critical space debris should be agreed within a group of countries which share the same objective, but eventually decided upon by the country that has the responsibility for it. Thank you very much.
Thank you very much, Tommaso, for your comments. And now I'd like to pass the floor to Ram Jakhu from the IASL, Associate Professor and Acting Director of the Institute. I should also point out that the Institute of Air and Space Law and the IAASS have been working together for a number of years and have done a lot of work, not just on space debris, but we're very actively involved also in a project led on governance as a whole, with different aspects of governance, and debris was one of the chapters addressing that issue in terms of sustainability. So Ram, lots of legal questions have been raised, and the floor is yours.
Thank you very much, Lucy. First of all, I'll welcome everybody to this webinar. There are advantages of being the last speaker, and there are disadvantages. The advantage is that I don't have to add anything which has been said. So what could have been invented has been invented. So I don't have to invent anything. And that's a bad thing. So I have nothing to say. But again, since I have the floor, so I may be duplicating some of the ideas, but explaining. I think the real good points have already been made, but I just want to add few fundamental things. I think we have not addressed why. Why should we remove it? What is there? And I think that is the most fundamental thing. If there's no need, then there's nothing to be done. And that has to be said. Chris's point is extremely valid. about the responsible behavior, and Tommaso made a recording. Who's the responsible behavior? And I have been in legal profession for decades. The guidelines are very good, so long I'm not hurt. So that is the point. The question is, somebody has to say, hey, you are responsible to remove it. That is something has to be said in that way. So that means you need some kind of a understanding among like-minded or the concerned countries as such. The second is, who should remove? Should I go and start bringing it down? Or why should Canada do it? Who? Somebody has to say, hey, this is your responsibility to clean up this mess, which you have created. But the law today doesn't say that. So that needs to be clarified and reiterated in certain ways. Now, I think the points, and I think that was the purpose of this study was, of course, with respect to organization. I think what we have not discussed is really, to me, is a more basic than organization. That is the agreement. That's an agreement among nations. Agreement, understanding of that. The organization is a vehicle. Organization is not the purpose. The purpose have an agreement on some fundamentals of like who should be removing it, why it should be removed, who should be paying, as Joe mentioned the point. An agreement which could be in somewhat start with non-binding resolution or declaration by countries, but then it has to come up to that level. There is an agreement, and then of course the organization needs to be looked at point. The other point is, and I do recognize my comments are not totally integrated, but I'm just trying to respond to the questions or points made up earlier. Now, this is a kind of animal or thing we are dealing with, which has very different aspects. They're equally important. The first is the state aspect, public aspect. Governments are involved, are responsible, and could be held liable. So there are private companies, but private companies do not have locus standi in space unless they're authorized by the governments. There's a very different situation in space as compared to other fields of operation. So the blessing has to come from the government. Secondly, governments cannot do everything and should not be doing anything. There's a role for private companies to be involved in this, should be undertaking that. And then it is the question of national level. Countries are sovereign, but they also have signed up the treaties, international aspect. So you have a public aspect, you have private aspect, you have a national aspect, you have international aspect. Who should bring and how they should bring all these people, concerned individuals, interests together? And that is why there's a need for understanding and also going towards agreement eventually with respect to the formulation of an organization, which will be, again, I agree with Jason, is that organization does not have to do everything on its own. It can or perhaps should outsource the work to the private companies in that way. But the blessing has to come from the governments. Now, the point, again, very valid made, so we should have a bottom-up approach, and I always believe in that. I don't believe in big governments, and I don't believe somebody telling me what to do that. But the question is, I cannot do the things over which I have no control. I cannot go and start bringing these pieces down, right? So that means there has to be some understanding. You say the Outer Space Treaty is an excellent example. Why didn't we have serious problems for 50 years? Because there was some kind of legislation, international legislation up there. So countries were concerned with, hey, this is what you can do, but this is what you cannot do. There has to be some kind of agreement at the top level. And the other is at the national level. National level, I think national laws are indispensable, but national laws are not sufficient. You need international agreement of some sort. Let me give the example. In Canada, a Canadian, just an example, a Canadian company wants to go and start removing space debris. But the company needs a license from Government of Canada. But there is no law, to the best of my knowledge, in Canada which authorizes that company to go and grab it. So you need national laws, domestic law, licensing system for that company to grab that. And the licensing system has to be what Chris' point is, question of requiring insurance. So national laws are indispensable, but not sufficient in certain ways. So you need to look at, to me, make the point. I think the proposal we had, it is not perfect. It is, as I said, a starting point, but you cannot say only, let me start at the bottom line. You say, well, let's look at only the national laws and let's look at the private sector only. No, I think everybody has to be put together and discuss it through at that level. I come back to the first point. Why one has to remove this pieces of debris? Somebody has to say and put in his signature, yes, that must be removed because that is creating a problem for me. And that unilateral declaration is not good enough. You need a government level understanding. And I keep on using the word understanding. Understanding does not have to be treaty first. It could be declaration. It could be a kind of other kind of piece which you start thinking that. So you cannot start only with one aspect. You have to look at every aspect in that. I have other points, but I'll wait for that. But maybe perhaps the space to be, I think Josef has mentioned the question of ITARs. But the other thing which we are not discussing is these machines or these tools or these devices are essentially for military purposes and the civilian purposes. Somebody will say, hey, we are removing this debris for civilian purposes. This has nothing to do with the military. But that has to be made very clear. Somebody has to make it clear in certain ways. So there has to be some mechanism at international level where the information is filtered through and exchange. And I said that I stop it here and I have other points. Lucy, thank you very much for your attention.
Thanks, Ram, for bringing up the dual-use nature, the importance of transparency and of exchanging information to ensure clarity of ADR and OOS. The way I'd like to proceed now is there have been a few questions coming in on the chat. I'd like to address one question to each of the panelists and then weave in the ones that are maybe relevant to you as we continue going along. We have decided to somewhat cluster the questions. So we're going to kick off with Joe, in view of the fact that the structure itself, the proposal of having an Intelsat-like or inspired intergovernmental organization seems to be key. A lot of comments have been made as to how can you adapt that to ADR. Could it succeed because the geopolitical situation is quite different than when Intelsat was launched? So Joe, based on your lessons learned when you were at Intelsat, what are some of the key areas that you would highlight that could help? And what are the huge challenges that you see with the Intelsat structure?
There are a lot of problems, and I think Stephen's list was a pretty good list to start with. I do think it is interesting that Intelsat really started with 12 countries. There were 15 who signed the agreement, but 12 had immediate effect. And that this was done in many countries under what's called the TIAS system. It wasn't a full treaty, it was an international agreement. And that Tommaso's point is a basic one, that we need to get national laws that are more or less in agreement. And that is the key, is that really we don't need an international organization. If we could have, let's say, 10 nations in the world agree to a model law that says, A, you will do everything to mitigate, you will, at the end of life, you will pacify your system, you will do everything to be at the highest model law. There's a really excellent article that I think will be in the Journal of Space Safety Engineering by Darren McKnight and Tom McClay, I think it is, that talks about having all of these standards as to all the things you would do in terms of trying to deorbit your satellites at end of life and so on. So that would be one set of the agreements. The other one would be to agree to a process for active debris removal. And again, I don't think the nations have to do it themselves. And if we could have the so-called garbage tax that would allow private enterprise to be reimbursed for their activities, that to me would be the most efficient way to go. But the bottom line is Intelsat was good in that it allowed private contractors to do the work. It was good in terms of it had a mechanisms for nations to agree together. But there are a whole lot of market issues, legal issues, and so on that really don't apply today. That was it. Lucy? Are we?
Lucy is muted. I was just wondering.
Okay.
Tommaso, do you want to take over? Or?
Because this was agreed already as part of this webinar. What kind of lesson learned I have from my direct experience on the orbitation? I have a specific experience related to the fact that when ESA had to perform the first the orbitation mission, this was for a cargo ship that was launched to the space station called ATV. So this was the first experience, and we arrived basically 1 year before launch without having into the agency requirements, methods, and estimate about the risk from a re-entry. I was put in charge of a team to work out, all the three. And we started with the requirements. It was not difficult to find out that there were some commonality about requirements. But then we discovered very soon that truly there were different methods. So even if the requirements were the same, the methods to calculate risk were different. And then there were some party inside the team that I was leading saying, hey guys, let's not waste any time. We spend 2 billion on this space system. We have to launch it. We just take, an extra insurance about, damages if it is coming down on Paris, or there were a couple of capitals, etc. And that's it. And my point was, how is possible that one day there is an accident and then the head of the European Space Agency is called and is asked, did you know the risk? And he says, no, we have taken an extra insurance. This is not a way of doing business. So methods, requirement must be common and must be, But there is another things that we understood in the course of this experience, that all the theory that we have about the risk for from re-entry covers very much the public on ground, but does not cover those traveling by air, the airplanes. And for the people on ground, there are shelters. At night, we are in buildings that have a certain amount of robustness, but an airplane is very vulnerable. And the first time that the community worldwide understood that space debris could be a threat for aviation was with the re-entry, uncontrolled, unfortunately, of the Columbia, of the shuttle Columbia. not many people know that the shuttle Columbia during re-entry was shedding an incredible amount of debris on a long track that was, close to a certain extent to Dallas Airport. And there were many airplanes that went through the falling debris curtain. There was one Continental airplane that went twice through the curtain. And that day, it was just a fortunate chance that there was no accident in aviation. So we have to understand that the issue with active removal of debris is not only to take care of stabilizing the on-orbit population of debris, but also to make it safely, such not to create a problem for public on ground, for aviation, and similar. Thank you very much.
This is Chris. I want to make a few comments in response to the other presentations. First of all, one model that we might be able to use is the IGA, the Intergovernmental Agreement that is used for the ISS, okay, which allocates responsibility and allocates, duties and obligations and that sort of thing. So that may serve as a model. Of course, the U.S., Europe, Russia, Japan, Canada are all signatories, and that may be a good model. Second of all, the issue of however you want to call it, a garbage tax or a bottle return, fee or something like that, it's been used before. If you impose something like that, can you guys hear me? I hear a lot of hissing in the background. Okay, it's just some hissing in the background. Tax is a bad word, right? It's important to make sure that there's a way to allocate any cost, whether it's a tax or a licensing fee or what have you. There are a lot of issues that you need to consider. So, is it by the number of satellites you have, by the total mass you have in orbit, by the risk of collision? Is it by which orbit you're in? I mean, there are a lot of different ways of doing it, and it might be difficult to get agreement. I don't think somebody with a 1U CubeSat at 400 kilometers or less should pay the same thing as, say, a 7-ton GeoBird or whatever. So there needs to be some sort of equity to any sort of calculation of what this tax or fee would be. So I think we have a ways to go on that. I did like Jason's comments on the the cost per kilogram of remediating debris. It's it's not linear, and standardization of hardware is very important, and we appreciate what Astroscale and others have done in that realm. The geopolitical situation obviously is very difficult. Ram's question about why do we need to remove debris in the first place is actually a good one, and we will have a bad day in space at some point. Some people say we've already had a bad day in space, but we'll have a worse one. And what we don't want to do is be sitting in front of our U.S. Congress explaining why we didn't do anything when we knew something should be done, and then they will impose restrictions that are onerous to the space economy. We would rather get out front on an international basis and make sure everyone agrees before we get a regime imposed on us. And there's a phrase I like that no one ever got a prize for avoiding a catastrophe that didn't happen. So we all talk about the fact that we need to do this. We all hope there won't be a catastrophe. We need to avoid one. We also have to recognize that there's a perception that, well, space is big, why do we have to do it? Again, nobody got a prize for avoiding that catastrophe that didn't happen, but safety is paramount. So I hope those are some helpful comments, and I welcome any other questions.
That's good. Lucy, can you hear us?
I can hear you, but can you hear me?
Yes,
Yes.
we can now.
Oh, thank you. The miracles
Now,
of technology.
Thank you. It's good to see you back.
Yes, nice to be back. My sincere apologies
No
for that. Of course, I've lost a little bit the train of discussion for the past couple of minutes, but let me see if I could dovetail in here. I also, unfortunately, because I had to leave and then reconnect, I've lost the chat feed with some of the questions, but there was one, and I hope that person helps me out if I don't correctly remember what he said, but in view of what Chris was talking about, insurance and cost, someone was mentioning the TTCB, three-country group that would want to be able to procure doing ADR services, but particularly it would particularly involve or assist removal of Russian old launch parts. And so the question was, would this not perhaps be an alternative model rather than have a large intergovernmental institution a la Intelsat with trying to start with a smaller model that just has 4 or 5 countries? Would that be a better way to be able to perhaps get countries that do have large objects that need to be removed rather than dealing through a huge intergovernmental institution? So I don't know if Joe wants to, if Joe's still there,
I would like
Joe wants to address
comment.
that. And there was also, from Chris's perspective, the fact about the funding. Could that help also with the insurance premium costs?
I would like to make a comment, very quick. There are in the proposal 2 aspects. One is what to do for the future and what to do for the past. It is clear that for the past there is no market unless the government decides to put down money to take out those upper stages and the default satellites. So there cannot be, there is no market. There is a garbage pile over there, and you cannot expect people to volunteer to go there with their own expenses, etc. So the government has to put the money in. Then there is the future. For the future, stopping doing what is happening now. Here you need the government not to pay, but to put rules. And these rules would be, you must have an assured deorbitation. Either you do it by your own means or you contract this activity. And on top of this, you take an insurance in case something goes wrong. So this is the idea at the basis of the proposal.
Lucy, I do think that Chris's remarks about the ISS franchise agreement could be a good model. And again, the basic problem is to get nations to agree that removal of debris is a key thing to do, put it into legislation, and the key is a funding mechanism to make it happen. One idea is some sort of a launching fee. Another is to combine it with launch insurance payments and so on. Again, the more debris you remove, probably the lower your space insurance fees. But the main thing is we need to get nations to agree to certain fundamental things, a very high level of mitigation, pre-launch mitigation, pacification, all of these things, and also to move to create some sort of fee to pay for this and to have contractors perhaps be licensed to remove debris.
Thank you. Chris, do you want to add something to that, or are you you're muted? You're muted.
Yeah, no, I hesitate to talk about, you know, insurance pricing and insurance being the sole solution here. I really do think that you know, insurance is just one way of mitigating risk. You know, you have avoidance and reduction and retention of risk. So insurance plays a role, but insurance, for better or for worse, insurance tends to be reactive to the state of the environment, to the state of the economy. So we would much rather see the people who are most directly affected, the satellite operators themselves, agree on some form of action rather than simply relying on insurance. We'll sell insurance to anyone who wants to pay our price, but that's maybe a secondary way of solving the issue. Does that make sense?
Yeah. Lucy, may I add a comment if that's okay?
Please do.
Thank you. There's so many rich comments that have been made. A reaction to one of them is we have in a sense a precedent about how we might act, and that is the whole debate about greenhouse gas emissions, and exactly the same, if you like, bifurcation that Tommaso talked about came up there. What do we do about the emissions that are already up there, and who is responsible? And what do we do going forward in terms of reducing and mitigating? And the scorecard, the report card on that is very poor, because the international community found it extremely difficult. I mean, they came up with formulae, but they weren't complied with. Extremely difficult to work out who should pay for the pollution of the past. There were lots of discussions about who is most responsible for it, who caused the pollution. Same discussion that we have now with the rocket bodies that are in space, and the finger was pointed at a number of countries. But in the end, those countries stepped away from the responsibility of meeting the cost to clean up. In terms of moving forward, there were, again, lots of debates about who should have responsibility. And we have this notion at international law of what's called common but differentiated responsibilities. That is, those that have the capacity should take the forward-leaning and essentially put their hand in the pockets to deal with it going forward. I think that makes sense, but the cost issue is something that really we have to. It becomes very difficult to fathom, because we are talking about adding costs to space missions, and in this trend that we've had in the past few years towards the miniaturization of many space activities, the, if you like, democratization of space has been because space has been more accessible to many more actors because the costs have come down dramatically. If all of a sudden we start imposing, and I'm not saying we shouldn't, but we must recognize that if you start imposing costs, additional costs, on those that undertake activities, if I'm the CEO of a company and I have $20 million to spend, and all of a sudden I'm told I have to spend another $10 million on whatever the additional costs are, I may make a decision not to go ahead with that activity. And it's a fine balance, because most countries wish to encourage space activities, wish to encourage industry and the development of their indigenous capabilities. And so when you start imposing costs, that might go against government policy, albeit that we all agree we have to do something. And, you know, again, I sound like the naysayer in trying to find a solution. I think we must find a solution, but we really need to sit down with everybody and work and recognize there are many moving parts to this. And we can't rely on insurance, because then, to be the panacea, because the insurance companies won't put up with that. They themselves might find that this is not a market they want to play in anymore. And then you have fewer access to insurance for some of the other activities. So there are lots of moving parts. And I think we just have to be conscious that we can't come up with a single solution without looking at all of the different considerations and trying to work it out together. And that's not easy. Thank you, Lucy.
But I think the numbers are key, that space insurance is about 12 to 15% of the cost of a mission. If this tax were, say, 3 to 4% for all missions, and again, different rates and percentages for different missions, small missions and so on, clearly would be different than and geo different and so on. But you'd have to have a tax structure that made sense. But I think it could be in the range of 3 to 4%. It doesn't have to be a huge percentage of the cost of the mission.
But we're not very good at taxes. This is my point from before.
Right.
There was.
I'm saying it's a fund, not a tax. But I'm just saying the numbers don't have to be huge.
There was a proposal that everybody would be aware of called a Tobin tax. Again, not to do with space, but there was a proposal that we could, towards the end of the last millennium, when people were talking about developing country debt, we could resolve that issue by imposing a levy that goes into a fund of, it was 0.001%, 0.001% of foreign exchange transactions. And the calculation, so absolutely minimal. The calculation was that if you impose that on governments and the banks, you will build up a fund, given the amount that's exchanged, that would wipe third world debt over a period of 10 years. A fantastic idea. Governments balked at 0.001%. And I'm not saying that's a good thing. All I'm saying is, we have to find ways of incentivizing, incentivizing good behavior, as everybody says. And that is, I think, by emphasizing the common interests we all have, because as Chris says, when we have that bad day, everybody will suffer. Literally 3 days ago, the ISS had to maneuver itself out of the way of debris. So this is a real issue that comes up every week, and we've had so many near misses. So I agree, it'd be great to have a fund, Joe, but I'm a bit more skeptical as to exactly how we can convince the stakeholders to contribute.
Stephen,
the lighthouse issue. How do you pay for the lighthouse?
So Stephen and Joe, I'd like to move on, actually, segue with what you were talking about, that you might actually, by having a tax, disincentivize the private sector. So I'd like to turn to Jason to have him address that issue, but also in terms of the maturity of the technologies for ADR. What is your assessment of that maturity and moving forward? We talked a lot about there's a need for a market, etc. So what are your views on those two issues?
Hey, Lucy. Thank you very much. Maybe I'll start with the technology one first in terms of technology maturation. I think it is very clear that space is rapidly advancing. It's moving forward towards more complex and capable missions in space. And ADR does require a lot of new innovative technology. So just to mention a few different types of technology we're going to need in future. For example, there's RPO, Rendezvous and Proximity Operations technology. So this is like guidance, navigation, and control. Everything you need to actually search for a client, approach a client, dock with a client. And of course, in the past, only limited cases of semi-controlled docking have ever been done. What we're proposing now to go up to an unprepared satellite, which may be tumbling, on all axes and things like this. This requires more advanced technology. If you take a look at capture technology, that's another big item. Astroscale has come up with this magnetic capture system, which is compliant with future docking plates and things like this. But that really is a key driver in future mission design. And finally, I can't help but mention things like ground segment and operational capabilities, which do require evolution. And these are things like flight dynamics and mission planning and stuff like this. But I want to mention that from a technology perspective, there is a crossover between what we call end-of-life services, active debris removal, in-orbit servicing. Josef mentioned before, the MEV mission, and all of this technology is connected. It's not independent. So when you start developing technology for one of these branches or one of these business lines, you're actually enabling many other services and future capabilities in space. I think I mentioned before a number of missions Astroscale and other parties are working towards. If you take a look at the ESA and the JAXA missions that are planned, we're going to have launches between 2023 and 2026. So, I would say that technology is being matured right now, and I think we're going to be in quite a good place in the next 5 to 10 years. So, there's always this question about, does technology lag legal or the other way around? And there's a chicken and the egg scenario. But in this case, I think, these kind of in-orbit demonstrations we're doing, and others are doing as well, are kind of proving the way from many perspectives, especially a technological one, showing that these things can be done. In terms of the incentives for debris removal, I think, there was a lot of discussion before about, who should be actually taxed in the past. I think, this is an ongoing discussion. And I think the proposal here talks about levying a fund on final users of space services, which could be the public. Of course, there are other funding mechanisms proposed in the past, performance bonds, bounties, things like that. There is a query, and I think this has been raised before, but why should the tax be directly on the public and maybe not on government or commercial entities which are responsible for procuring the launch and operations of satellites? For example, just to give an example, a space debris tax may be made proportional to how sustainable a particular mission or constellation is. You could have metrics developed and agreed at the international level. One of those, for example, is the World Economic Forum Space Sustainability Ratings. I think this was mentioned before, and that aims to, the principles of it, is to give a kind of rating to how sustainable your constellation or your satellites are in future. So, of course, things like this do help to incentivize good behavior in space. So, there's just a couple of points there.
Thanks very much for your input, Jason. I'd like to pursue on the technology front and perhaps ask Isabelle, what kind of future vehicles could be foreseen that would actually grab the old rocket parts to be able to bring them back and re-enter Earth? What are the prospects on that front?
I guess that the prospects were quite well described by Jason first. For sure, it's something which is common with other thoughts about in-orbit servicing, to refuel satellites in order to repair, to add some other equipment if you have a failure of sensors or things like that. For the moment, it's something which is not so much developed, I guess, in Europe, because there is no real market in front of that. And we always come back on the same things. Is it to government to put in place the business associated to that? Because we have to fund the development of such vehicles, either for pure debris removal, either for in-orbit servicing, and at the end, perhaps before coming back to Earth, coming with another satellite or rocket body? Or is it to start right now because we will launch many flights for constellation deployment? So this kind of tax, even if the word is not very sexy, but an incentive linked to the fact that the most satellites we put on orbit, the most it will be difficult to go through this kind of orbits. And till we have not solved this question of funding the business, from industrial point of view, it's very difficult to have self-funding studies. So we have for sure, phase zero studies, pre-project, think tanks and things like that. But for the moment, it cannot go very far because there is no associated, how can I say, business or frame or or legal enforcement to do that. The French Space Operation Act, it's for now, for 10 years ago, and for the future, but it's not a recovery of the past. And this question of recovery of the past, I love some sentences that no prize for avoiding catastrophic threats that don't happen. I love that because it's really the case. Till we don't have major accident, it will be difficult. And we had accident. We had some very difficult collisions generating a lot of debris and so on. But even with that, the awareness of the catastrophic situation that we could face one day, not to be able to launch with a good reliability through these first layers of space, even that, it's not enough today. So I guess that as soon as we will have a solution to begin really technological work at a high level in order to have a demonstrator for such vehicle and so on, it won't be a problem because we can do it. The problem is, from industrial point of view, to have fun to do it because there is no market. There is no market on that.
Yeah, it's clear.
Thanks. In fact, that's a good lead to you, Tommaso. This is somewhat of our technical cluster. So in view of your considered experience with ESA reentries, what's your assessment of spacecraft-controlled deorbiting? And what are the alternatives?
Yeah, as a matter of fact, during the outage that you had, I covered this point, but I would take the opportunity to just add a few words by saying that who has created the market for seat belts? The market for seat belts, low emission, etc., has been created by regulations. So it is the government that by imposing the right regulation would create the market immediately. So if there is no will, political will, there will be no regulation because the regulations are bad and because the regulation should be cancelled. But there are various types of regulation. There are regulations that are economic, let's say, burden, and regulation which are safety related, which, I mean, if you remove it, you are adding cost, not removing cost. This is my comment. Thank you.
Yeah, this is Chris. I just want to follow up on Tommaso's comment specifically about seatbelts. I remember when I was young, and many of you have heard me say this before, when I was young, seatbelts were an option that you could pay extra for. You actually had to pay for the to have seatbelts in your car. It was an option. It was you pay for it. But then, of course, everyone realized that the regulators and the auto companies realized that it actually saved lives, and now you can't get a car without seatbelts. So I mean, seatbelts are actually an interesting example, Tommaso, because we used to have to pay for them. It used to be, oh, you want safety? Got to pay extra for it. So you can see that the tables can turn because of that.
Very good. Thank you.
Chris and Tommaso, thank you for your comments. In fact, now I'd like to address some questions to Ram. There's from the audience to build up a little bit. If you wanted the seatbelt, you had to pay for it. There's someone in the audience who raises the point that if you're a private corporation like SpaceX and you can afford to send thousands of satellites, should you not have to pay more? And the specific question is, could the ITU somehow impose higher fees based on the number of satellites being launched and their radio frequency spectrum? So I know it's a little bit off of the proposal, but it is linked to the fees and the taxation and the funding aspect of this proposal.
You see, that is a very good question, I say, but I will, I'm all for that. I think ITU can do that. And so to me, ITU is a forum. So this is what I was mentioning, who should decide that? To me, ITU is the perfect forum to impose that kind of a requirement because it has been imposing similar requirement with respect to radio frequencies and also with respect to orbital positions. Now, the question is, ITU itself does not do anything. It is the governments who decide that. So the governments have chosen ITU as a forum to impose those restrictions. So this was the point I was making earlier. I mean, things do not happen in the air. Somebody has to take initiative, and that somebody has to take initiative because it is in his, her, or its interest. To me, it is a matter of fact, the other point I was going to make, and it's very relevant here. Now, the major users of space today, they are the one who should be concerned about it because they are the one who is going to be using more. So to me, these countries should bring these kind of matters before ITU. Maybe perhaps COPIUS may not be the right place. Perhaps COPIUS should not be excluded, but ITU is another way of doing getting these kind of taxes or imposing, I would say, restrictions with the use of regulatory mechanism. But in addition to ITU, I think ITU, if we can say ITU, regulations works not because of ITU. It's because the governments implement ITU regulation domestically. And so the radio frequencies which are kind of assigned or registered with ITU are being respected in all countries. So that brings my point here is the governments have to have a regulatory system in place where they have agreed upon something internationally and implement that, and that is why ITU is very effective. So I definitely agree with the proposal.
Thanks, Rambu. I'm looking at the time. There's about 10 minutes left. And so what I'd like to do is, I know Stephen addressed the whole issue about the way that the global community has reacted in the past to potential taxes. I'm wondering, one of the other points that you raised when you listed some of the issues with the proposal concerned the decision making and the diplomacy itself. People have, everyone has said that you need to perhaps favor a bottoms-up approach. Governments clearly have a key role to play, as does national legislation. It's a complex issue, so you need to get the technical people with the legal people. How would you pursue and see this part of the puzzle in terms of the diplomacy and steps that could be taken to move this call to action forward? Stephen was there 10 seconds ago. Stephen, are you still with us? Mind you, it's quite late for him. So perhaps if perhaps he's having difficulties as I had earlier, I think that same question perhaps could also be addressed to Josef in view of some of the work that you've been doing from the policy side. And you actually brought up the whole point of the bottoms-up approach. You also mentioned that perhaps some countries who had a greater interest needed to get around the table first. What would you like to add to the discussion on that point?
Yeah, thanks. Thanks for, in order to add to that point, as I said earlier, I'm really in favor of a more bottoms-up approach. Professor Freeland perfectly pointed out that, in today's climate environment, it is apparently very difficult to bring people together on the same table. So I think number one priority should be to have one country within a country work on active debris removal, and then as a second step, maybe perhaps on a bilateral agreement. And I don't think this even needs to be a bilateral agreement sort of in that big legal sense, but perhaps just a memorandum of understanding that each country will follow its regulatory environment and who pays and what is done, right? Who works on the mission, and just to make sure that all the regulatory environment is fully followed through. And so I think really as a next step, what should happen here, while I find this proposal very fascinating, is to have a very solid technical and legal conversation, but at a more of a venue I would envision at like the Interagency Debris Mitigation Committee, the IADC. I think that would be a good venue to continue the conversation, to identify the pieces of debris that should be removed, and to identify funding mechanisms, opportunities, and technological challenges. Because I think if you start at a smaller level, the legal issues that have been pointed out earlier, I think might be very well resolvable. And one more comment I would like to make regarding active debris removal and the issue on people on the ground, airplanes, debris falling from the sky. You know, ADR stands for active debris removal. So I would envision not to be a passive reentry, but actually an active reentry where the debris would either burn up or it would be delivered into the ocean, into the Pacific. So I think some of these issues are just resolved on a case-by-case basis. But thank you very much. I yield back to you.
Thank you. So we have reached the point where I'd like to quickly ask the panelists for perhaps in 1 minute, 2 maximum. And Joseph, I will consider that what you've just said is your closing statement. So I'll pass the floor perhaps first to Jason.
Okay, thank you very much. Yeah, so as I mentioned earlier, I think, you know, the space debris environment and space sustainability, you know, it's a mix of things. It's cleaning up the existing debris that's up there, but it's also, you know, dealing with the vast number of new satellites that are going to launch, which a set number are going to fail. I strongly believe that IOD test cases such as ELSA-D, which I mentioned, are launching later this year, you know, very important in a number of ways. And similar to what Joseph was just saying, you know, they develop your technology and mature that. They go a long way in the development of local state regulation and licensing. And they do start to open up international collaboration between states. For example, you take the ELSA-D mission, both the UK and Japanese governments are involved. So this is really a test case for how this thing can go forward. And of course, these type of missions, you know, they're test cases for policy being developed in many groups as well, such as, you know, groups are involved in like CONFERS and Space Safety Coalition. And of course, we try and develop norms and best practice for future missions. But of course, this requires feed-in and experience from ADR missions. So I think the way forward is to continue with this process of doing initial demonstration missions and kind of these initial individual state-to-state kind of processes for engagement. And of course, based on that, I think it could be opened up to a wider group going forward. So thank you very much.
Thank you very much. Could I ask Isabelle to please make a brief final conclusion, their final statement based on the discussion that we were part of today?
Well, on twofold. The first one is that we really have now good best practices written in a very good way. We have the example of the French Space Operation Act, so there is clearly no limitation that for the future all the countries adopt with the way they want, but with an enforcement, adopt all these practices to protect the future, clearly. And on the second fold, for the recovery of the past, from my side, I would be keen to issue a kind of convention as they did for Intelsat, just putting at the same table the right people at government and space agencies level in order to think about. Probably it will take months, years, but if we don't begin with such kind of convention, it will never go on. So let's start to see people on the table just focused on this subject and not like Kopos on all space sustainability. It would be my proposal.
Thank you for those words. Tommaso, I now pass the floor to you for your brief final statement.
Before, sometime well before this webinar, I had a conversation with Don Kessler, okay? Don Kessler is an honorary member of IAASS, and I sent him this proposal, and I received a very positive feedback, basically saying that this could be the kind of approach that solves many political problems. In particular, we have to consider that if the development of these capabilities is done internationally, immediately we, let's say, solve the issue of the dual use, because everybody will have that technology in their hands. This of the dual use is not, of course, a new topic related to on-orbit service, etc., because the first to launch open technology for this has been DARPA in the United States. So DARPA has done a lot of studies on in-orbit servicing and capture of satellites and have published their technology. So the only way to go around the issue of dual use is technology. And this is the other point that I wanted truly to underline about the positive aspect of this proposal. Thank you, Lucy.
Thank you, Tommaso. Stephen, may we hear your final statement? You're muted.
My apologies. Yeah, my apologies. I think my internet has already gone to sleep, and I'll follow very shortly. Firstly, thank you again, everybody, for all your comments, and thank you to both Ram and Tommaso for the invitation to participate. I think, you know, we are all in violent agreement that there is a major issue in front of us. And that if we continue on a business as usual case, then as one of our colleagues said, we really do face the possibility of a tragedy of the commons down the track if we're not careful. It's taken a long time for the international community to recognize that mitigation in and of itself is not a solution. Indeed, mitigation means adding more pollution, albeit at a slower rate. But it took a long time for the international community in the UN to accept the word remediation as part of the strategy. But now it is part of the strategy. Now we have companies like Astroscale and many others developing the technologies, developing the possibilities. We have the insurance companies that are recognizing their role in this, and we have the academicians and international organizations that are putting forward proposals. So we're moving in the right direction. My own feeling is that I agree the bottom-up approach makes a lot of sense, and you are already seeing that. You are seeing implementation, international law of various strategies for limiting debris. So many countries now require already, when licenses are applied for, debris mitigation plans, debris strategies, end-of-life strategies. And I think that is a tendency that will continue. So I think we will be driven by things happening at the national level, but ultimately, as everybody has said, we need to find standards and we need to find an understanding as to responsibility. Those discussions are taking place. They will be difficult, but it's fora like this, it's proposals like the one that was put forward by the IASL and the IAASS that I think generate the debate, generate the ideas that will allow us to find a path. Because in the end, we have to find a path. If we don't find a path, if we have that tragedy of the commons, if we have that Kessler effect of cascading debris, then ultimately every country, large and small, industrialized and non-industrialized, will not be able to garner the benefits. And so there's an imperative there, notwithstanding our disagreements on Earth, there's an imperative to find a common path forward on this, undoubtedly one of the major challenges of space. So Thank you, everybody, for your comments. Thank you again. I'm about to turn into a pumpkin at 2:30 in the morning, but I'm delighted and grateful to have the opportunity to participate with such a wonderful panel. And Lucy, thank you so much for organising and running it so smoothly. Thank you. I'll say good night, but I'll wait until Ram closes the event a bit later on. Thank you.
Thank you very much, Stephen. When I was a graduate student at the Institute, the director at that time was Nicolas Matt, and he would always say in French, nécessité fait loi. So if you need something, people will find an interest, they will get together and they will move something forward. And I think that this initiative taken by the IASL and the IAASS is the first step in that. And I think the real value, as can be seen by the richness of the comments, is the fact that the panelists and the people who in the audience came from very diverse backgrounds and were able to bring forward the different challenges and try and move the agenda forward. So it was a real honor for me to get to know some of you. I've seen names of people that I have not seen in a long time that participated in the audience. So that's a pleasure. And thanks very much again for a wonderful webinar, and for one that I think has planted many seeds and has raised many questions, and perhaps will give us future opportunities to continue the discussion. And on this, I'd like to pass the floor for the closing word to my good friend Ram. Thank you.
Thank you very much, Lucy. Very, very quickly, I must say that I've learned a lot. This has been, at least in my view, very successful webinar. Primarily because I said it, because I learned a lot. So from very subjective point of view, I think it was very good. Secondly, from the organizational perspective, I will say this was the purpose, and it gives me confidence that our proposal was not that bad. But this is what it was used as an example to initiate dialogue. And I must say with full honesty, all the comments made by everybody are excellent, valid. And that means the final solution to this problem will be a combination of all those ideas together. One single approach will not be good. So it cannot be accepted that only the treaty will be good, or the bottom-up approach will be good, or it doesn't really matter what is. Technology cannot solve the problems, and the private sector cannot do things alone. So the ideas, perspectives, and interests of everybody has to be combined, and one has to find solution to this problem. The solution of the problem is, to me, is imminent. I think if I can say that the situation is different as compared to Intelsat. There was no urgency. There was no really that immediate need for that organization or in a way emergency. Here is, in my view, it's an emergency kind of thing. Otherwise, things are going bad. There, things were, Intelsat was created to improve things. Here, first thing is to control the bad things, and which are urgent. So I think it will not take longer than, certainly not as long as Intelsat took it. But those thoughts, I want to express my sincere thanks to all the panelists. And if you please allow me to say two very special people. My very good friend, Stephen, at 2:30 in the morning, you are great. You're still as fresh as I am, but maybe better than me. And Lucy, you did a wonderful job. Thank you very much for your guidance and your steering the wheel. And irrespective of all these minor technical hatches, you've done a wonderful job. Thank you very much. And there are people who are not in the front, at least one was there, Kiran was there, and David Chen and Ramasamy. They have done a wonderful job in the organizing the whole event. And again, all the participants from different countries, I think we went up to about 230 participants, and I think it was wonderful to have them participating in this webinar. Again, thank you very much, and bon voyage if you are not traveling and virtually traveling. And we hope to see you in person sometime. And it has been very successful in my view, and thanks to you all. And I declare the webinar closed. Thank you.